He was ordered to attend a rehabilitation program focused on alcohol and drug awareness, along with impaired driving education. Those who successfully complete this program can gain significant advantages: reduced jail time, smaller fines, shorter license suspensions, and even the possibility of avoiding probation under the Department of Corrections. Over the following months, the court granted him multiple extensions to finish his program obligations, but he still couldn't complete them within the usual time frame. After several postponed hearings and missed deadlines, the court finally set a plea and sentencing date for June 25, 2024, before Judge Melissa Mogan.
Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Right.
And that's all kinds of fun today.
Sorry about that.
Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or fact.
Math is usually not fiction.
Yeah.
It's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honestly, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Your Honor, I think it's made. The issue, and this brought up with Ms. Anderson, is he had a question about the grams per 100 milliliters.
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
It's just that I was measured in thousands, and the law goes by hundreds.
You can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce
and yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late. Okay, you're not supposed to be late to court. Okay, you're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance, and now you're here debating
I'm just
science.
saying, anytime you put a numeral behind the decimal, Like one numeral behind the decimal is a tenth. Two numerals behind a decimal is a hundredth.
Yep.
Three numerals behind a decimal is a thousandth.
Yep. I know math.
Okay. And a thousandth is 10 times less than a hundredth.
Well, let's cut that off, okay? You blew a 0.22 with a PBT.
221.
Or 0.221, okay? So you were 0.22. We'll give you the benefit of the doubt. No more with that one, that thousandth, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how a thousandth is 100.
2. Relying on his self-proclaimed AI research, Mr. Lamprecht presented a baffling defense. He claimed his blood alcohol concentration, BAC, wasn't above the legal limit because it was measured in thousands rather than hundreds. This argument revealed a glaring lack of understanding of simple math. In decimal form, each digit after the decimal point divides a whole into smaller fractions, tenths, hundredths, and thousandths. The more digits, the more precise the number becomes, not smaller. To put it plainly, a BAC reading of 221 isn't less than 0.08. It's nearly 3 times higher. His entire claim collapsed under basic arithmetic, exposing just how deeply flawed his reasoning truly was.
That off. It's 0.22. It's 0.22.
No, if there's 3 numerals, because if it was point...
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math...
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth, though. It's a thousandth or it's not.
Okay, it's a thousandth or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask your questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then so give me the knowledge because I like math. And
here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail. Get out. I got a job.
All right. So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right. Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a 0.221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily?
Yes.
Are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm not, I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate
Okay.
time, okay? This
Okay.
isn't a time to conversate.
Okay.
This is a plea and sentencing
Okay.
in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right, because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keene, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right. So based on this, the OWI third, count one, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be merged and dismissed with count one. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP, but he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 and the third offense, which I believe is $1,911 for fines and costs. That's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keene.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also, as with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means I'd be careful about even like non-alcohol alcohol, because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system, because OWI 3 is the last one. It's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement. Ms. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI 3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the, less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
No, nothing that I haven't already.
Well, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is, again, serious. You're putting yourself at risk, you're putting others at risk. The fact that you blew a 221 had blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for interrupting.
Don't interrupt me again. You interrupt me again and I will hold you in contempt. I will hold you in contempt and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Okay.
I need to ensure that the public is going to be protected, and that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before.
Judge Mogan firmly reminded Mr. Lamper that a fourth OE conviction would elevate his charges to a felony. Under Wisconsin law, each subsequent offense for operating while intoxicated comes with harsher consequences. The first three are misdemeanors with growing fines and jail time, but the fourth transforms into a Class H felony, carrying at least a $600 fine and a mandatory 60-day jail sentence. Beyond the courtroom, a felony record brings lifelong repercussions, loss of civil rights, employment barriers, housing limitations, and restrictions on firearm ownership. The state's tough stance makes one thing clear. Repeat drunk driving isn't just a mistake. It's a serious crime,